Good morning and welcome to the first argument of the Tuesday session of the March 2022 Kansas Court of Appeals oral arguments. My name is Leslie Ann Isherwood and I will be presiding over today's hearings. I would like to take a few moments just to introduce the other members of our panel. First, Judge Henry Green, who's been with our court since 1993 and is currently our longest serving judge, and Judge Dave Bruns, who's been with our court since 2011. In preparation for today's hearing, we have reviewed all of the briefs and documents that the parties have filed, as well as their corresponding records and a research memorandum that has been prepared for us. And while we are intimately familiar with this case, the same is not necessarily true for those individuals who may be tuning in to view the live streamed or archived version of this argument. So I have kindly requested Appellant's counsel to provide a brief factual overview so that everybody that is tuning in can kind of get up to speed and have an understanding of how it is we got to where we are. The case before us is scheduled for 15 minutes, and I will be keeping that time as well as any rebuttal time, so the parties don't need to be concerned with that. And with that, I would like to call the first case, number 124173 from Johnson County, Mary D. Wurster versus Homevestors of America, Inc. Would the parties please announce their appearances?
Thank you, Your Honor. Lauren McCluskey on behalf of plaintiff appellant Mary D. Wurster.
May it please the court, Ross Bowden on behalf of Homevestors. I will also be making the argument on behalf of all of the co-defendants today, but I'll let counsel for the co-defendant introduce himself as well.
Yes, I'll be the silent party here. May it please the court, I'm Jonathan Sternberg and I represent the Appellee's Pride Properties LLC and Marcus Bray.
Ms. McCluskey, would you like to reserve any rebuttal time?
I would like to reserve 3 minutes, please.
Okay, 3 minutes is granted, and with that, you may begin.
May it please the court. Your honors have asked me to do a brief overview of the facts before I sort of jump into the argument here. So a brief overview is that in 2017, Mrs. Wurster accepted an offer from Appellee's Homevestors of America, Marcus Bray, and Pride Properties for the purchase of her home. It was supposed to be a $1,115,000 sale with a 30-day closing with a cash offer. Appellee's never actually closed on that sale, and instead it turned into a contract for deed and a promissory note, which gave them possession of the house before they actually paid the purchase price. Mrs. Wurster eventually sold the house to a third party for $825,000. She filed her original petition in the district court in August of 2019, and Bray and Pride Properties filed answers and counterclaims. Homevestors filed an entry of limited appearance for the purpose of filing a motion to dismiss for lack of personal jurisdiction and a motion to stay discovery for lack of personal jurisdiction. Then in December of 2019, Mrs. Wurster entered into a settlement with Bray and Pride Properties. Homevestors refused to be a party to that settlement. Then the settling parties joined together to file a motion for mutual dismissal and proposed journal entry. Mrs. Wurster then retained our office in 2020. We filed a motion for leave to amend the petition, which was denied by the district court and is the order from which we're taking this appeal today. So I'll just jump right into it. Since the facts apply a little bit differently to the different appellees, in order to simplify things, I've sort of organized this into what we see as the 3 statutory issues that we'd like the court to consider, and then I'll address some legal issues raised by appellees in the briefing after I get through that. If I'm not able to get to everything today, we don't waive any arguments, we stand on the briefing. Mrs. Wurster takes this appeal from the district court's 2021 order denying her motion for leave to amend the petition. I'll be referring to this as the 2021 order. It was abuse of discretion due to an error of law for the district court to hold that it lacked jurisdiction to hear Mrs. Wurster's appeal. In its 2021 order, the district court reasoned that it did not have jurisdiction because the 2019 joint motion for mutual dismissal, which the district court says was granted by way of the 2019 journal entry of dismissal, that she lacked jurisdiction to hear that. Also in the 2021 order, the district court stated that it lacked jurisdiction because no post-trial motions or motions to set aside the journal entry were filed. The district court's reasoning constitutes an error of law contrary to Kansas law, and this should be remanded to be heard on the merits in the district court. The three main questions we'd like this court to decide is, was the 2019 dismissal of Gray and Pride Properties a dismissal without court order pursuant to 6241A1, or was it a dismissal by court order pursuant to 241A2? Second, was the December 5th, 2019 journal entry of dismissal a final appealable order which dismissed all claims as between all parties? And third, does this court have jurisdiction to hear the appeal? As to the first question, was the 2019 dismissal of Gray and Pride Properties a dismissal without court order or by court order? We assert that the 2019 dismissal was a dismissal without court order pursuant to 6241A1. For dismissal to be without court order, the parties must file a stipulation of dismissal signed by all parties who have appeared. After the stipulation is filed,
Counsel,
yes.
Point to me in the record where there's a stipulation.
Yes, Your Honor, we assert that the joint motion for mutual dismissal operates as a stipulation.
Okay, so you would agree there's no actual written stipulation pursuant to the Kansas Supreme Court rules?
We believe that the joint motion was incorrectly titled a joint motion, and that by operation of law and under 6241A1, that it met the requirements of that statute and therefore satisfied that Kansas statute and operated as a stipulation.
But it's not just the title of that motion. If you look at the text of that motion, it specifically says that the parties jointly move this court for an order dismissing all pending claims with prejudice. So it seems a little far-fetched, but help me understand how we should disregard the words in the text. Now, I understand how maybe the caption doesn't control, but why should we disregard the words in the text and count this as a stipulation and not a motion asking the court for an order of dismissal with prejudice?
Well, we believe that when the parties jointly moved, that it was the parties moving to dismiss their claims against one another. Homevestors refused to be a party to that motion, refused to be a party to the settlement agreement, did not sign the motion, and also did not sign the order except to say that it was unopposed to the journal entry as well. So we believe—
But let's take them out of play just for a second. As to those who actually signed it, anyway, wouldn't you agree that on its face, that is a motion asking the court for an order of dismissal with prejudice?
We believe that when that joint motion was filed, that by operation of 6241A1, it acted as a stipulation of dismissal.
Well, wouldn't any time that parties settle a lawsuit and file a motion asking the court for an order of dismissal with prejudice, wouldn't all those that we don't need both statutes? You could just, all of those would fall under that statute and would somehow magically become a stipulation. I just don't follow your argument.
We agree that that's what happened, but we don't agree that it dismissed the claims as to Homevestors. We do agree that the claims as between Gray and Pride Properties on the one hand and Mrs. Wurster on the other hand were dismissed with prejudice at that time.
Okay, so we're only talking about Homevestors then.
Correct.
And before you get too far, you reviewed the facts, but one thing you didn't mention is in this motion to amend the petition, there was some attempt to even change the parties to a trust. Is that still your argument?
Well, I'll be quite frank with you, Your Honor. When we got this case, it was after these 2019 motion and proposed orders were filed. It was really with the intent of giving Mrs. Wurster the opportunity in her day in court against Homevestors who refused to settle with her. When we looked at the case, we saw that the home at issue here was actually owned by her trust. And we agreed that it's a little weird to sort of change up the parties at this point, but we are trying to get it legally correct. We are trying to do the right thing. And so when we saw that the trust was involved in ownership of the property, we just wanted to get it right. But
okay. And I'm sympathetic to the fact and we should state that for anybody watching that your firm was not involved in this initially. However, you are now. When did the trust come into effect and own this house?
before any of this happened.
So they're a separate legal entity under Kansas law, isn't that correct?
That is correct, Your Honor.
They weren't a party to this lawsuit, were they?
We agree. No, they were not.
And they weren't a party to the real estate contracts? I mean, they were all signed by Mary Wurster individually?
When I look at the case, I see that title was when they sold the house to the third party, the title was transferred by the trust to the buyers. You know, I'm not.
But as far as the dealings between these parties,
it was
the trust was not involved in it at all, it appears.
I agree.
Okay.
And, you know, if I had a time machine, I would like to be able to go back and get that right from the beginning. But unfortunately, all we can do with what's in front of us is try to get it correct now.
Sure.
So we've talked a little bit about why we believe that the stipulation is without court order. I'll next move on to the second question, which we'd like to address, which was the 2019 journal entry a final appealable order which dismissed all claims between all parties? The question is important because if the 2019 journal entry was a final appealable order and Mrs. Wurster wanted to amend her petition, she would have had an obligation to file some type of timely motion to set aside a judgment. The district court incorrectly made this holding in its 2021 order, which we assert is an error of law, which constitutes an abuse of discretion. Appellees also make this argument in their briefs. We assert, however, that the 2019 journal entry was not a final appealable order. First, because as we discussed, we don't believe that it disposed of the claims as between Mrs. Wurster and Homevestors. And it therefore follows that because it did not dispose of all of those claims, it would have had to contain an express determination that there was no just reason for delay pursuant to 6254B. The 2019 journal entry contained no such language, and therefore we don't believe that it was a final appealable order. And this court has jurisdiction to hear the appeal based on 60-2102A4, because the 2021 order was the only final appealable order entered in this case.
As a general rule, though, in Kansas, doesn't dismissals with prejudice serve as a final judgment that is appealable?
As we believe that for 6254B, that a judgment that does not dispose of all claims as between all parties is not a final appealable order without that express determination that there's no just reason for delay.
And then if that's true, do we just put blinders on to the fact that the journal entry on its face says that it includes the words you just used, quote, all claims, and all parties. It says that it hereby dismisses the above captioned matter, including all claims filed therein against all parties with prejudice. Are we just supposed to disregard that language?
Well, what we're asking the court to do is take the journal entry and read it in its entirety, which the first line says that now on this blank day of December 2019, the parties' joint motion for mutual dismissal comes before the court. So we think it's an equally reasonable position for this court to take that the journal entry merely granted the joint motion. And we assert that the joint motion was just a stipulation of dismissal as between Mrs. Wurster and the settling parties, the parties that were a party to the settling agreement and not Homevestors.
But let's say we disagree with you. If we disagree with you, then it seems that we have to interpret this on its face. It was appealable at least, and the time to appeal it would have been then, not now.
Well, I guess that's the crux of our argument, and that's the sort of statutory and issue that we're asking the court is to interpret this journal entry. But we ask that the court look at the record as a whole and see that the other thing is the journal entry was really unnecessary. If we, and we hope you do, agreed that the joint motion was a stipulation of dismissal without court order, then that ended that dismissal right there. The journal entry really was unnecessary.
But we have to put blinders on to get there. Let's look at something a little more, maybe a little more practical here. What claims is it that you still want to bring on behalf of the trust?
Well, the main objective is we believe that there are two Kansas Consumer Protection Act cases that we'd like to bring, and then as well as a fraud case.
Okay, those are the two claims. And you're asserting in your amended petition that you would like to file that those are claims that should have been brought by the trust and not by her individually. Is that correct?
Well, we would like to bring the claims under the Kansas Consumer Protection Act as Mary Wurster in partnership with her trust. We don't believe that she.
You probably anticipated my question is which would be whether the trust, but we don't have to decide that now, whether the trust would be entitled to a Kansas Consumer Protection Act or even a fraud claim. Is there anything that's stopping you from bringing that lawsuit right here, right now for a separate entity if you have a good faith lawsuit on behalf of the trust?
Well, we thought the proper way to do it under Kansas law was to amend our petition, because when we looked at the case, we didn't think that it was properly disposed of. And as to the ability of the trust to bring the KCPA claims, we believe that Mrs. Wurster, in partnership with her trust as a family partnership, can do that. And we also have the fraud claims as well. So it's not just the KCPA claims. And we believe that that's an issue of first impression in the state of Kansas. But we do have a little bit of.
But isn't that a separate lawsuit because it's a separate entity?
It could be.
And you could fight your battles there as opposed to here.
I haven't, Your Honor, at this time explored that, and I don't know. There may be some statute of limitations issues or something like that.
Oh, there may be all kinds of issues, and I'm sure counsel would prefer that you not do that, and there could be all kinds of things. I'm just trying to figure out here. It seems to me taking a separate entity and trying to interject them in this case, as cloudy as this case is already, is a problem. In your arguments, as far as that journal entry in the motion, although I think they're very creative, I think is really asking us to almost do a Wizard of Oz, don't pay attention to the man behind the curtain.
Well, what I would ask this court to pay attention to is the error of law in the 2021 journal entry that we believe constitutes abuse of discretion and should, we believe you should look at the record as a whole in coming to that conclusion. And those other issues regarding is there an ability to bring the KCPA claim of the trust and some of the other issues that appellees raise in their briefing, we believe that those are more properly addressed at the district court after this court agrees with us that it was an error of law and an abuse of discretion in the 2021 order.
Ms. McCluskey, you are into your rebuttal time. You may waive that time and go ahead and proceed, or you can save it and use the 3 minutes you've reserved.
I'll go ahead and save it. Thank you.
Mr. Bodden?
May it please the court, and just as a reminder to your honors, I'll be making the argument on behalf of all of the defendants here. In this appeal, plaintiff is asking this court to ignore her own filings, emails, and a court order, all explicitly dismissing all claims against all parties with prejudice, and somehow conclude the case was not dismissed with prejudice. In other words, plaintiff wants the court to conclude that her own words mean the exact opposite of what she said. And plaintiff makes this argument without any legal authority. This court can dismiss or affirm this appeal based on 2 determinative facts. First, the trial court entered an order explicitly dismissing with prejudice all claims against all parties that was voluntarily drafted and filed by plaintiff. Second, 9 months after dismissing the lawsuit with prejudice, plaintiff filed a motion to amend the pleadings without filing any motion to toll the notice of appeal deadline or to otherwise reopen the case in any manner. On those facts alone, the court can dismiss or affirm this appeal. This appeal presents the court an opportunity to confirm several important concepts under Kansas law. First, that a voluntary dismissal with prejudice is a final judgment that starts the notice of appeal deadline. Second, that the denial of an unauthorized post-judgment motion is not an appealable order under 60-2102A and cannot be used to get a second chance at an appeal. Third, that a trial court lacks jurisdiction to entertain any unauthorized post-judgment motion after a dismissal with prejudice. Now, before jumping into my argument, I do want to make one quick comment as to the argument that I heard from plaintiff's counsel, which I believe conceded that all of the claims were in fact dismissed against the co-defendants, Bray and Pride Properties. If that's not the case, I guess plaintiff's counsel can address that in rebuttal, but that's what I took from that argument. So I'm going to be focusing strictly on Homevestors here, but all of the co-defendants are aligned in these arguments either way. So getting into the jurisdictional arguments, there is no appellate jurisdiction here because what plaintiff has effectively done is filed an untimely notice of appeal. And because the denial of plaintiff's unauthorized post-judgment motion was not an appealable order. As to the timeliness of the notice of appeal, the journal entry of dismissal with prejudice was absolutely a final judgment that started the notice of appeal deadline. At that point, unless plaintiff files a valid motion or a timely motion to toll the notice of appeal deadline, plaintiff's appellate rights disappear 30 days after that dismissal. But here, plaintiff did nothing for 9 months and then filed an unauthorized motion out of the blue and attempts to appeal from the denial of that unauthorized motion. Allowing this procedure would effectively eliminate the notice of appeal deadline. Additionally, the court can dismiss the appeal because the denial of an unauthorized post-judgment motion is not an appealable order under the plain language of 60-2102A. We all know the right to an appeal is limited by statute and must fall into one of 4 general categories. Plaintiff argues that denial of her motion for leave to amend falls into the final judgment category, but that's plainly not the case. And plaintiff cites no legal authority supporting that position.
Counsel, let me interrupt you just a second there because it goes back to your jurisdiction argument. I understand what you're saying on most things, but don't we have appellate jurisdiction to decide that question, which is the question of whether or not a final judgment was entered in that with the dismissal with prejudice? Because that's one of her claims, is that dismissal with prejudice was not a final judgment. And I think civil procedure law from probably at least since the 1960s would say that it is, but It seems like we would have jurisdiction to decide that issue.
Yeah, the court can have jurisdiction to determine whether or not a final judgment that plaintiff is calling a final judgment was in fact a final judgment under 60-2102A. But I think that is a jurisdictional issue. That's more the point that I'm making, I guess.
Well, all right. And once we determine, let's say if we determine it isn't, that's different. But if we determine it is a final judgment, and I think we probably are duty bound to do that based on prior Kansas Supreme Court law. If we do, then I think your jurisdiction argument falls into place.
Yeah, if you determine that the denial of plaintiff's motion for leave to amend was a final judgment under 60-2102A, then yes, the court would have jurisdiction if that's what the court is saying.
And would you agree, since I've already interrupted you, would you agree that the trust is not a party to this case and that it's some separate legal entity that your client may or may not even known about?
That's correct.
Okay. Because here we're just talking about her individually in this case.
That's correct. And her attempts, I guess, by the trust to essentially intervene and file a motion for leave.
Yeah, to change the parties with a separate entity. Okay.
That's correct. So getting back to the jurisdictional issue, Kansas law is clear that appellate jurisdiction is limited by statute and also strictly enforced. Although post-judgment motions are impliedly limited by statute, Kansas courts have not explicitly articulated that limit. And that's where the 10th Circuit cases that we cite provide helpful guidance. In the 10th Circuit, a proper and timely Rule 59 or 60 motion must be filed before a court can entertain any post-judgment motion. So taken together with the already in place Kansas law, the proper holding here is that denying an unauthorized post-judgment motion is not an appealable order unless the plaintiff files a motion to reopen the case or somehow set aside that prior dismissal with prejudice. To conclude otherwise would effectively create a loophole permitting an endless cycle of litigation where parties can file any frivolous post-judgment motion they want to and then appeal the inevitable denial of that post-judgment motion. There has to be a limit on this process somewhere, and I believe the 10th Circuit provides a good model to follow. For those reasons, the court can dismiss this appeal for a lack of jurisdiction. Now, getting into the merits of plaintiff's appeal, all of plaintiff's arguments hinge on the misrepresentation that the case was not dismissed with prejudice. There's no credibility in that argument for a number of reasons. Dismissing a lawsuit with prejudice is one of the most fundamental procedures in litigation. Every lawyer knows exactly what it means to say all claims against all parties are dismissed with prejudice. And that's exactly what plaintiff did here. Yet plaintiff asked this court to look at the dismissal with prejudice that she voluntarily drafted and filed and conclude that it's not a dismissal with prejudice. And plaintiff makes that argument despite her representations to the trial court after filing the dismissal with prejudice that in fact confirmed that the case was entirely dismissed. The rest of plaintiff's arguments are a series of red herrings. Plaintiff contends the journal entry didn't comply with 60-241, but plaintiff misconstrues that rule and doesn't even apply the correct part of the rule. Under 60-241, there's different procedures for dismissals with a court order and without a court order. Here, the case was dismissed with a court order, so plaintiff's arguments about dismissing a lawsuit without a court order are irrelevant. Next, plaintiff argues the joint motion actually dismissed the lawsuit and not the journal entry, and that the court should be looking at the joint motion as opposed to the journal entry as to identify the document that actually dismissed this lawsuit. But the problem with that argument is the joint motion says the exact same thing, explicitly dismissing all claims against all parties with prejudice. So that argument doesn't make any sense either. Plaintiff then tries to attack the journal entry itself by arguing that Homevestors did not sign the journal entry. But that's plainly not accurate on the face of the journal entry, which clearly bears my signature. But regardless, the signature issue is just another red herring. Whether or not Homevestors signed the journal entry is irrelevant. Under 60-258, the law only requires a judge's signature for a journal entry to be effective. Parties are not required to sign journal entries. And it's also important here, I think, to take a step back and evaluate plaintiff's actions following the dismissal. If we are to take plaintiff at her word that she truly believed this was an active lawsuit, plaintiff would not have sat on the case for 9 months after the dismissal with prejudice. At the very least, this is a textbook judicial estoppel situation. As we all know, judicial estoppel precludes a party from taking inconsistent positions in litigation. Here, plaintiff offered to dismiss the case with prejudice in an email to all the defendants, followed through on that offer and actually dismissed the case with prejudice, represented to the trial court that the case was in fact dismissed with prejudice, and now tries to argue that the case was not dismissed with prejudice. This is exactly what judicial estoppel was intended to prevent. For those reasons, if the court does not dismiss this appeal, defendants request the court to affirm the trial court's ruling or to apply judicial estoppel. From a practical standpoint, this appeal really kind of presents a test of the ultimate goal of the litigation process, in my view, which is to have a just, speedy, and inexpensive determination of disputes. Stated another way, the goal is to reach finality as efficiently as possible, not to create loopholes for endless appeals through frivolous post-judgment motions. Yet in this case, more than 2 years after a clear dismissal with prejudice, defendants are still here paying their lawyers to litigate whether a dismissal with prejudice was in fact a dismissal with prejudice. That's really a pretty astonishing statement. If the court does not dismiss or affirm this appeal, it will create tremendous uncertainty in the dismissal process, which is one of the most critical functions in litigation. Therefore, defendants respectfully request the court to dismiss or affirm. And unless your honors have any further questions for me, that's all I have.
Seeing no questions, Ms. McCluskey, you have 3 minutes on your rebuttal time.
Thank you. And your honors, I understand that if you view the facts the way they're presented by appellees, it doesn't feel good. They want to make it seem as if, you know, this is some greedy plaintiff trying to go at this twice. But I agree with counsel for appellees that a dismissal is an extremely important pillar of our judicial system. That's exactly why we have 60-254B, because we want certainty in our orders dismissing claims. If an order dismisses fewer than all claims against all parties, there is language that's supposed to be in that order that was missing from the order that they're saying was a final journal entry. I would also ask the court to look at the record. Appellees kind of take things a little bit far when they say that prior counsel for Mrs. Wurster, mentioned that she had to settle claims with all parties in order to get the house sold. That's really not what she said. We believe that she was able to get the house sold just with settling the claims with the parties that had counterclaims against her. The claims with Homevestors really had nothing to do with the sale. We also encourage you to take a closer look at the record and see if what appellees are saying about the email exchange with the district court really does make judicial estoppel appropriate in this case. We say that it does not. The journal entry was signed the day before that email exchange took place. It therefore could not have induced the court into acting any certain kind of way. So I think big picture, we're just asking the court to take a real look at the record and the actual words that were used in the emails and the timestamps and things like that, taken together with counsel's failure to comply with Kansas statutes as it relates to stipulations of dismissals and journal entries and things of that nature, and find that the district court committed an abuse of discretion due to an error of law, and let us be heard on the merits, and let Mrs. Wurster have her day in court against the party that refused to settle with her.
Thank you, and thank you to the parties for your arguments. We will take the matter under advisement and issue an opinion as quickly as possible.